Today I'm privileged to be chatting with Dr. Annelie Gildenhuys. Annelie is an industrial sociologist and a master human resource practitioner who specializes in employee relations, conflict management and diversity management. And one of her many roles has been that of commissioner on two statutory bodies, the Commission for Employment Equity and the Essential Service Commission. So thank you so much for joining me today, Annelie. I really do appreciate it.
Thank you.
As Commissioner for the Commission for Employment Equity, you were part of the task team who worked on the amendments for the Employment Equity Act, as well as the new Code of Good Practice on the prevention and elimination of harassment in the workplace, right? And this code was, of course, gazetted in March this year.
Yeah, that is correct. The Commission developed the code and published it for public comment, and based on that amended it. And of course it then went to NEDLAC, where the social partners eventually agreed to the document we now have, and then it was gazetted on the 18th of March, correct?
Excellent. Well, it's really good to have you to chat to about the background to the code then, and what went on in terms of the planning for developing this code. So it certainly has generated a lot of attention and interest since it's been gazetted, and I would say that's not only amongst the employment relations field, but even in the mainstream media. So I wonder if you could maybe tell us a bit about the background to the development of the code.
Well, I think internationally and in South Africa in particular, the whole aspect of discrimination and harassment and gender-based violence is a key issue. And South Africa very early on indicated that it would be prepared to ratify the International Labour Organization Convention 190, which is the convention against for the prevention and elimination of violence and harassment in the world of work. And so, of course, the question was, were we in a position to ratify? Do we have the legislation? It was our view that we have a plethora of law in South Africa in addressing this. But the interesting part is that although we had codes of good practice on handling sexual harassment, the broader concept of violence and harassment is how we dealt with it, and what needed to be dealt with. The other issue is that we were faced with a number of different definitions of harassment, but in particularly, for instance, you would have two various different definitions in employment law, in that the 2005 codes, had two different definitions, and then had different definition in PEPUDA and PFHA. So in looking at it, we had to see that how do we align our code of good practice to the Constitution in South Africa, to the existing Employment Equity Act and the codes, and what needed to be done, and specifically to address the obligations of all the parties involved. And this is really what led to a new look at dealing with the concept of harassment. And I think the other aspect is also very particularly the broader interpretation of harassment, and not just the focus on sexual harassment.
Yeah, and I mean, in line with that, of course, the code also talks very specifically to the concept of workplace bullying. So to what extent did that bring about your interest in this new code as well?
Because of the broader concept of violence and harassment, the ILO convention sees it as one concept. We in our code had dealt with violence being part of harassment, but you would see that the code specifically deals with the broad concept of what is harassment, which is of course dealt with in the Employment Equity Act in terms of a concept but not defined. So the concept of harassment was never defined, and the code then aimed to be very clear on what harassment is. and to align to what we have in Section 6.1 of the Employment Equity Act, which is a tricky aspect in that harassment, workplace bullying could be harassment, but not necessarily discrimination. Whereas we know that discrimination includes very specific aspects of harassment if it's on the listed grounds. So, but that the concept is particularly there and defined. And what was important is to define that and to say what is harassment, what does it look like, what are the elements, and then to deal with the tests in terms of, is it an objective test, is it a subjective test, or is it the reasonable complainant test, and was it a combination, and was it the same for all of the forms of harassment. And I think that the code aimed to do that in clarification. But certainly the term mobbing was included, and workplace bullying is a concept of harassment or manifestation thereof, because we know that that is particularly prevalent in the workplace.
Well, I mean, just thinking about the prevalence of these types of behaviors and experiences within the workplace, what do you think is going to be the key impact of this code on South African workplaces practically?
Well, I think what is important is this is not new for us. We have a constitution that prohibits unfair discrimination. We have the Employment Equity Act, we have the Health and Safety Act, and the Promotion of Equality and the Prevention of Discrimination Act, the Prevention of Harassment Act. So legislation we have. What I think the key aspect for the code is that it very much deals with the broader concept of harassment and defining it, as I mentioned, and then it deals with the obligations of the employer. I think the direct, vicarious and statutory liability of employers has always been part of that. And if you fail to deal with your obligations under Section 60. So for me, key is that the code actually assists us in addressing that, in how do you prevent harassment, discrimination and GBV in the workplace, and when it manifests, how do you deal with it? So the key issue for me is that employers would very specifically have to review their policies, more particularly how clear they are on the complaints procedure. This was already in the 2005 Code on Sexual Harassment, is that your complaint procedure differs from a normal grievance procedure in how you immediately deal with aspects. So one is to have a very clear policy and procedure, particularly complaints procedures, the formal and the informal, and having forms of mediation or being very clear on how matters are referred to formally. And I think that the other aspect very specifically is the need to train and to have an awareness. But the code specifically talks almost, I think, 3 times in that you must train. And it's not a case of once off, but to deal with this concept ongoingly in training and to monitor your status and areas of potential hotspots. And I think for me that is part of what you ought to be doing in how you analyze the barriers to fair employment in the Employment Equity Act in any event. But again, for me, key would be the role of policies, complaints procedures and training in order to look at it, and the role of trade unions and other parties in this. I mean, the code goes as far as saying that CCMA commissioners and those dealing in deciding these cases should be trained or must be trained.
Yes, yes.
And that to me is going to be a key aspect, is that employers have to deal with their proactive duties to prevent, and then to be clear on when an incident does occur is how do you respond to that.
You've mentioned to me previously that you are working with a good number of very well-known corporate entities in terms of creating awareness around this. Are there any anecdotes or any results of the work that you've been doing with organizations out there that you think may be of interest to us in terms of how the code is playing itself out at this point?
I think the whole concept of harassment, the concept of unfair discrimination, is really complex, and aspects, and people are concerned about workplace bullying, in that that we're going to have just number of complaints because I don't like the fact that my manager gave me negative feedback. And there I think or that, as we've seen in the press, well, can I get fired for just rolling my eyes at somebody?
Yeah.
I think, again, the whole concept, the broad concept of what harassment is an abuse of power. And it is different from perhaps an autocratic leadership style that I don't like. But it is when we get to an abuse of power, and there I think that the elements to be present for it to be an harassment case is important to know. But I think anecdotally what we know is that people don't speak out. They don't want to speak out because either way, how do I say that it's a harassment? I've been the subject of that, and the whole concept of gaslighting is quite important, where people sort of are made to feel, well, what did I do to do this? But it's the impact of harassment. Why are we even looking at that? It's not because the law makes it an issue, but I think what is important is the impact. For me, anecdotally, in most of the companies that we deal with, is the impact on performance, and in a company is when there is sexual harassment and it's rife, and that everybody knew and doesn't speak up. And the same with workplace bullying. And I think when we look at the impact thereof, it is of concern. What is interesting is that no matter how big the organization is that I think very often managers don't understand the vicarious liability and often turn a blind eye. And then I'm always amazed at the fact that you would find in the industrial relations or ER policies just a little bit of a mention of sexual harassment in a paragraph, and it refers to the grievance procedure. So that's what I mean, is that I think there's an impetus on employers to really relook its policies. And then what is interesting to me is very often the norms and the values in an organization is where people say, well, this is just how we do it. And, you know, do you mean that we can't even make jokes or whatever? And it is wrong. And what about workplace relationships, romantic relationships? These are very difficult concepts to start dealing with, is because by the very nature, the small word of unwelcome makes it subjective, and it makes it difficult. So I think, and the code talks about the words unwelcome, unwanted, interchangeably, or unacceptable behavior for that concept, but it remains a very, very subjective test then, because the only person who knows that it's unwelcome is the recipient.
Absolutely, yes.
So I think that just having the dialogue in companies and as part of the awareness is starting to talk about it, to establish new norms and values of what is acceptable and what is not acceptable behavior. In the interest of the productivity in a company and contribution and addressing it.
Yeah, I mean, this discussion is just making me realize once again the human nature of the employment relationship. You know, we are people in relationship with each other as human beings at the workplace. And when you speak about the potential impact on the complainant, I think this code is of enormous value and will continue to allow people to become more and more aware of, as you say, what is acceptable, what is not acceptable, what have we brushed aside, brushed under the carpet up to this point, and what should we be paying more attention to as employers. So, Annelie, I look forward to further conversations with you in future. We look forward to working with you potentially on an upcoming webinar on the subject matter. And yes, once again, I really do appreciate your time with me today. So thank you so much.
Thanks for having me.
Thank you.